Hello everyone, and thank you for joining us for the Hybrid Workforce Employment Law Aspects webinar. My name is Suzanne Allen. I am Event Specialist for SEMA UK Events team, and I will be your host for this event. We're delighted today to welcome Lauren McLaughlin and Jessica Bass, Curzon Green Solicitors. Before I hand over to our speakers, there are a few points I would like to make. To minimise disruption, you have all automatically been muted. If you would like to ask anything, please enter details in the questions box, as there will be a short Q&A at the end of the webinar. Following this session, you will be sent a link to the recording. Thank you, and without further ado, I'll hand over to Lauren and Jessica.
Thank you for that introduction. So Lauren and I are both employment solicitors and partners at Curzon Green. We both regularly act for both employers and employees on a number of issues. Curzon Green Solicitors are a full-service law firm operating in High Wycombe, Marlow and the City of London, and our employment team is rated in the Legal 500 as a leading firm for employment issues. On what we're going to go through today. So first of all, we're going to look at the legal issues relating to hybrid working. Then we're going to speak about discrimination and bias risks. We've got 10 tips on successful hybrid working, and then we'll be going through a question and answer session. So Lauren's going to start you off looking at the legal issues surrounding hybrid working.
Thanks, Jessica, and good afternoon, everyone. We're going to start looking at the basics behind hybrid working, and we'll get straight to it. So in research commissioned by ACAS this year, in March to April, unsurprisingly, 60% of employers surveyed have seen hybrid working increase. A very common scenario at the minute is where employers are requesting employees to come in 2 to 3 times per week. 52% of employers have, however, seen staff working from home full-time, an increase. Despite this, there still appears to be uncertainty and caution in actually enforcing formal hybrid working arrangements. Employers have good reason to be cautious. After working from home for almost 2 years, almost without adverse effect, employees now expect employers to be flexible, and the market this autumn we're seeing is clearly tipped in the employees' balance. Nobody wants to be heavy-handed when competitor employers might be more flexible and pay just as much, if not more. So employee perceptions have changed and shifted, and there's no longer really a standard way of working. What's clear is that hybrid work is here to stay, needs to be managed correctly, and that's legally and practically. The advantages we've heard of successful hybrid working from our clients include productivity, job satisfaction, attracting better talent and retaining them, lower turnover and good employee morale. In the longer term, employers may seem able to reduce premises costs and so on. Downsides are also apparent, however: reduced collaboration, teams becoming more siloed, increased isolation, reduced oversight, problems with inclusivity and communication, training those at their early stages of their career, and issues around data security and confidentiality. Increasingly, we are seeing concerns with online harassment and bullying too. So when considering bringing in or formalising hybrid working already in place, employers should consider practical arrangements. So what needs to be done, what technology we've got, communication, support, meetings and team days. What do your clients and customers expect, and how are we dealing with our new joiners? Looking at the contractual side of things, all employers by law must provide a written statement of particulars of your employment. This needs to include key terms like hours and place of work. It's often referred to as a Section 1 statement, and all employees and workers have a right to one of these by day 1 of work. Where changes are made to your terms, you actually need this change in writing within 1 month of the change, and that's a Section 4 statement. A change from office-based to hybrid working or full-time home working will trigger the legal obligation to give a new written statement. And on the slide are just some of the things which you'll now look at, which need to be updated in your contract. There's a good chance that your current contract doesn't deal with hybrid working adequately unless it's been recently updated. So looking at your place of work, your contract must state your place of work, or if you work in various places, let's say at home and in the office, an indication of that and the employer's address. So your contract should have been updated if you are working at home. Some clauses do give employers flexibility, so you will see a mobility clause on your screen, and this seeks to give the employer general flexibility to move the employee around. But the idea of that was really to move around offices. Tribunals expected employers to use this power reasonably. So for instance, it would not be reasonable to move someone, say, from one part of a country to an entirely different part of the country, and doing so could risk a claim where the employee sues for breach of contract or constructive dismissal. So in absence of a mobility clause already in your contract, consent's needed and an updated term should be issued and accepted. Many workers will probably be delighted to accept and will be happy to see hybrid working in their contract, but some may not, and the issue is to get acceptance. An example of a hybrid clause you'll see on the screen. It could go further. You could have your parameters, how many days in the office, how many days at home, but some prefer a more loosely worded clause to offer better flexibility. Either way, it's really important that the right to work at home is included in the contract. Otherwise, you are potentially technically in breach of your contract where you're not in your place of work. The trend to work hybrid and remotely has increased to outside the UK too, and that's likely to continue, in part because of the sophistication that we've got of technology, and also because we can work effectively from anywhere. It seems to be the opinion of many. One of the first points to consider, though, if this can work, is immigration status. If the employee is working internationally, they might not actually have the legal right to work remotely for the UK employer in another country. What's the visa requirements? Since the UK left the EU, British citizens no longer have the automatic right to work in the EEA. So you need permission to work from EU member states. And failure to comply with this could have implications for the employee and also for the employers. Irrespective of the employment contract, if you are living and working abroad remotely, you may acquire local employment rights in the host country. Could include minimum pay rates, which are higher than the UK, more annual leave. What about public holidays in the country you might be working in as opposed to your home country? And what happens in termination of employment? Do you have different rights? So local employment advice should also be sought. Your benefits, things like private insurance and pension requirements. Some medical insurance policies will only kick in if you are in the UK. Pension requirements might change from country to country. So this must be checked. Generally, in terms of tax, an employee who works abroad for less than 6 months will remain UK tax resident. If you're working abroad for more than 6 months, there are tax implications. For Social Security, the general rule, again, is that contributions are paid where the work is performed. So if you're actually working outside the UK, you might be needing to be contributing to Social Security there. So employers really need professional advice on this. Also, international work could result in the employee losing Social Security benefits at home, so they need to know that. Looking at data protection laws apply whether when working abroad, and especially if data is transferred from the UK to another country and back. So you need to be thinking about data protection breaches, which could result in fines for the employer. And really the place to start there is your data protection policy and making sure it covers international work. Duty of care for health and safety continues to apply. So even though individual is not in the office, employer has a duty to make sure that there's a safe system of working, even if it's abroad in a remote location. And you need to be checking that you're complying with the country's health and safety laws too. The employment contract might have post-termination restrictions. So for instance, a non-compete clause saying the employee can't compete with a business within 5 miles of the London office. That's not really going to work or be practicable if you're actually working in another country. So dialogue is obviously crucial, along with the right professional advice, but in most cases cross-border working will be achievable, but there needs to be clarity, and legally this needs to be set out in the contract too. So section 1 requires that if you do work outside of the UK for more than 1 month, the contract or a written document needs to explain how long you will work outside the UK and the currency, among other things. Briefly on hours, these need to be monitored because the 48-hour maximum working week continues to apply. It's very difficult to monitor this when employees are working at home. There's also a requirement to take rest breaks and meal breaks. So there's no change in the contract other than the monitoring and enforcing it. So employees should be required to make sure contractually that they are taking these breaks. If there are core hours that employees need to be available, this should really be set out in the contract and agreed. At the same time as thinking about minimum days in the office, a requirement to require employees to come in to the office for meetings or disciplinaries and grievances and so on. An employee working from home will incur expenses, internet, phone, light and heating, but there's no legal obligation to cover these expenses. However, the employment contract really should outline what the employee can and cannot claim for, or direct to a policy which covers this. I say this because if there is nothing in the contract which covers this, a tribunal could infer that these expenses are due. An employment tribunal awarded over £2,000 as a contribution to a claimant's household bills to cover 2 years working from home on £4.28 a day. The claimant was dismissed and brought a claim for other things, but this included their home expenses, and the tribunal concluded that the employer owed the employee for using his home as a workplace. Compensation was determined by looking at the utility bills against number of days working and the number of days of holiday. In that case, there was high-speed internet installed, and the claimant had increased insurance costs with a company computer. So it's something to bear in mind. We've also got the imminent energy crisis. So we have seen in the news John Lewis and so on coming forward to offer benefits to cover things like heating, electricity, food and so on. Obviously this works the opposite way too, so smaller businesses are seeing a squeeze, but either way, the point being this should be set out or agreed in a contract or a policy. Finally, on equipment, so if you've got equipment, this should really be covered by your employer's insurance policy. But if that's not possible, the employer should really require the employee to take out cover and really should be covering that cost. The employee should check their home insurance or lease allows them to work from home. Some terms don't, and they could be invalidated. And the employee might want to think about limits on cover on individual items if they have high value items at home where the employer's insurance is not covering it. Looking at confidentiality, this is important if using a lot of, which you will likely have, a lot of confidential information at home. Sensitive data needs to be protected, and this is very difficult to police when you're at home, or even more so if you're working in, let's say, a public environment like a cafe, if you are permitted to do that. So on that basis, it should be set out exactly where you can work, looking at the place of work clause, and make sure that any breaches of any confidential information policy is dealt with seriously as a disciplinary. The employer would want to consider data protection precautions too, and setting this out and agreeing it. So access by household members, turning your screen away, are you allowed to have calls in a room or must it be in a private room, passwords and encryption, and confidential waste disposal. Have you been given a shredder or confidential bin? Has this been considered? The contract should set out how hybrid working can be ended, of course, otherwise neither party has any clarity if it can be and how it's done. It's also sensible to have an initial trial period if the employer has concerns about it, or indeed if the employee has concerns. Unison suggests a clause such as that on your screen, and it gives the circumstances where home working can be ended. Additionally, we would advise a notice period to bring hybrid working to an end. However, in practice, once you've embarked on hybrid working, it's very difficult to enforce an employee to return to full office-based work, even if the contract does include something like this. That's because of legal risks. So discrimination or bias in your treatment, which we will look at, if the employee believes the employer has acted in breach of trust and confidence and been unreasonable in forcing them back to work, could give rise to constructive dismissal or a breach of contract claim. So it doesn't come without risk, even if this is covered in your contract. And just looking at some other legal issues, so you've got health and safety. Obviously, these apply whether in the office or at home. So employers should be conducting a risk assessment for your working at home, and that looks at the various things that you might see on your screen, such as stress, working without supervision and ensuring that you take your rest breaks. What about your papers and your cables lying around, equipment that goes wrong, screens. Mostly it will be a low risk, and employers can take relatively easy action to solve any issues, but it's important that these risk assessments are conducted, and a policy on health and safety is up to date to cover people now working on a hybrid basis. All employers of 5 or more employees must have a written health and safety statement anyway. Thinking about management, so there will need to be a shift. So less on what employees are actually doing, are they at their desk, how long have they taken from lunch, and more on the outcome and their results, because people are working flexible hours. Appraisal objectives may need to be modified, and practical steps in your disciplinary and grievance process should be reviewed, meetings to be allowed over Teams. Has misconduct been updated, which prohibits you doing domestic chores during working time, for instance? We've seen things like that change. Employees should feel able to raise their concerns despite being at home and out of the office. So anti-bullying and harassment policies should be updated to ensure they cover online work, chat, Teams as well. And employees and employers and their managers should be trained in spotting and dealing with this. And finally, putting the updated contract elements aside, it's our view that a policy on hybrid working is going to be your most effective way of managing this really growing sphere for both sides. So not only should you have an updated contract, but a policy that can be looked at from time and updated from time to time. There's a natural shift we see from businesses currently taking a relatively laissez-faire approach to hybrid working to a more formal approach. And it won't be plain sailing. There will inevitably be disputes and claims, and it is an area where claims are being tested for discrimination, for instance. But it's obviously easier and better dealt with when we've got hybrid working, which is properly handled and managed with a good contract in place and policies that managers are trained in. You can see on the slide how we say that a company or a business should go about bringing in a policy, so proposing, circulating and consulting on it, making a policy, and then looking at the individual's needs and updating their specific contracts to make sure that everyone has something up to date and fit for purpose. We're now going to move on to look at some of the risks which we did flag in a bit more detail: discrimination and bias.
Thank you, Lauren. So I'm going to look at discrimination bias in respect of hybrid working. So when we talk about bias in this kind of sense, we're talking about unlawful bias, which is based on legislation, but we're also talking about wider bias against certain employees, which may not fall foul of that legislation, but is certainly something that we should be aware of and look to discourage. So looking at the legislation side of things, the Equality Act provides the right for individuals not to be discriminated against because of 9 protected characteristics. So those protected characteristics are set out on this slide. This relates to all employees, it relates to workers, it relates to job applicants, and the Equality Act goes beyond that in respect of transport, education, everything like that, but we're only going to look at employment for now. So in terms of employment, it ensures equality and that people can't discriminate across not only terms of somebody's employment, but also in a way that the employer affords an individual access to opportunities, so for promotion, transfer, training, or to receive any benefit or other service. There's no minimum service rights, as I say, so this applies to all employees equally. And the risk of getting it wrong is that you might be facing an employment tribunal claim, which comes with an uncapped award, and also the reputational damage that would also come with a Equality Act claim. However, on this, both Liz Truss and Rishi Sunak highlighted that they had issues with the Equality Act. Both suggested that they were looking to move away from protected characteristics to a more holistic approach. So the Equality Act does look to be on the current government's radar for change. So in terms of who benefits from hybrid working, Lauren's touched on this, but just in respect of particular groups, in theory, everyone can benefit from it. However, specifically, it's good for carers. So statistics show that 1 in 4 people working in the workplace now are carers. Hybrid working gives them the opportunity to fulfill those caring responsibilities both before and after work in time that might have otherwise been spent commuting, in their lunch break, and also allows them to be more easily on hand for any issues. It's good for people who may struggle to get in and out of an office. So, for example, you may have disabled employees who may not be able to access the office as easily. So that could be individuals who have mental health issues. So they may benefit from a quiet space. They may have comfort working from home in a familiar territory. And according to the Office for National Statistics, the depression rates doubled since the start of COVID-19. So it's certainly something that we need to keep on our radar as employers in terms of people's mental well-being. Those that may struggle with physical health issues, hybrid working can also assist them. So it might assist with taking out difficulties in a commute. They may already have their home adapted to any of their specific needs, and it also allows flexibility for individuals to attend medical appointments. Neurodiverse employees may also benefit from working from home, so people with conditions such as autism, dyslexia, dyspraxia and ADHD. The office environment is not always conducive to the best work for them, so individuals might suffer from things from sensory overload. Fluorescent lighting in offices is linked to difficulties with dyspraxia. They may struggle on a busy commute, or they may have a preferred communication method which may not be face-to-face. And then finally, hybrid working benefits working parents, and statistics show that this is it's more affects women than men in terms of caring responsibilities and working with children. Hybrid working will offer things like flexibility around school run and other benefits like that. And Lauren's also touched on this, but in terms of what's going to benefit you, so studies show that more diverse and inclusive workforces perform better, so you'll be creating a culture in which everybody can progress. You'll have a greater talent pool that you can hire from, so you are no longer limited to those in the geographical area that can commute to you every day. It's shown to increase productivity. However, this does cut both ways. Recent statistics show that people who work from home at least 1 day a week did up to 6 hours more unpaid overtime over an average week compared to those that never worked from home who did 3.6 hours. So we're not necessarily recommending that as a benefit, but it has shown that they do more work. It will reduce things like utility costs for you and potentially workspace requirements if not everybody's in on the same day. And it also has benefits in terms of employee satisfaction and mental health. However, not everybody is fully on board with working from home. So just this week, Lord Alan Sugar has come under fire for his comments on people that are working from home, referring to them as lazy gits, suggesting that everybody is at home golfing and that they should be getting back to work. Lord Alan Sugar has said that anybody who requests working from home on a job application and is immediately shown the door. So that's something to keep in mind, that not everybody fully agrees with this. However, unfortunately for Lord Alan Sugar, the government is currently consulting on making flexible working a default position, so making it day one right. So it's certainly something that businesses are going to have to embrace in some form. And then looking now at proximity bias. So the BBC has said that this is an unconscious and unwise tendency to give preferential treatment to those in our immediate vicinity. So if somebody's out of sight, they're potentially out of mind. And this is an extension of what we call affinity bias. So people that we like, people that are similar to us, we tend to want to do nice things for. And that's particularly prevalent in the workplace. There's a few examples of that. So for example, presenteeism. So the idea that you have to be seen to be present at work, to be seen to be working. So this is something that obviously Alan Sugar's comments have touched on, that if you're not seen to be working, then what are you doing? And the ONS have said that 39% of people feel that there's a negative stigma attached to choosing home working. In terms of other things, so water cooler moments and decision making. So if you can cast your mind back to 1999 to a memorable episode of Friends, Rachel Green, Ralph Lauren executive, misses out on a trip to Paris because her boss is smoking outside with somebody else. Rachel tries to take up smoking, which again we do not recommend as a solution here, to try and mitigate that water cooler moment, that decision making. So it shows there that people that are physically next to you are potentially going to benefit. Current statistics show us that 44% of staff believe that those who work in the office are more likely to be favoured by senior team members than those who are hybrid working. 2 in 5 worry that less face-to-face time with senior staff will slow down their own progression, and 22% fear that at worst this might mean that they're overlooked for promotion. It's also a chance that people will miss out on things like mentoring opportunities, and that particularly affects more junior workers and women. So again, it's something that we need to be considering. Why is it important? So biases are obviously unconscious. It's important to consider these risks so that you and your management team can understand how these biases against hybrid working can affect decision making when it comes to career advancement and equal opportunity, to then hopefully be able to prevent them. And then looking at some specific risks. So Section 13 of the Equality Act prevents what we call direct discrimination. So this is where somebody treats another unfavourably than they would treat other people because of a protected characteristic. There's an example here. So for example, if you refuse hybrid working to a female employee who has children because you think she'll be distracted, but you agree to a similar request by a male employee, then that's likely to be direct discrimination and unlawful. You can only justify direct discrimination in very, very limited circumstances, and that is where it's authorised for age discrimination. So where the treatment is a means of achieving a legitimate aim. So what is going to be a means of achieving a legitimate aim is very much going to depend on the job role and what the discriminatory conduct is. So, for example, a building company who have a blanket policy of not employing under 18s on hazardous building sites because to protect young people, because they may have statistics that support that individuals that are under 18 are less developed in physical strength and may have less experience that means that they can't function on these sites without hurting themselves or others. That's likely to be a justifiable proportionate means of achieving a legitimate aim. However, if you cross-reference that with a fashion retailer who says that a middle-aged woman can't work as a sales assistant because she's too old for the customer base that somebody's targeting, that's not likely to be a proportionate means of achieving a legitimate aim. And then Section 19 of the Equality Act prevents what we call indirect discrimination. So the sort of legal definition is set out there, but what it basically means is that you have a provision, criteria, or practice, so something like a policy that you apply to everybody that works for you. So in theory is non-discriminatory, but it affects and puts somebody who has a protected characteristic at a particular disadvantage compared to other people. So for example, if you had a policy where you said no employees in this role are allowed to do hybrid working, then that may disadvantage a disabled employee disproportionately, so somebody who finds it difficult to travel in. However, with indirect discrimination, it's possible to what we call objectively justify this again. So if you can show that this PCP is a proportionate means of achieving a legitimate aim, then you may be able to justify it. So, for example, if the job role in question was as a masseuse, then that obviously can't be done remotely. The proportionate means of a legitimate aim is making sure that everybody is there to perform those treatments. And then I'm going to look at reasonable adjustments. So this imposes a duty on employers to make reasonable adjustments to help disabled job applicants, employees and former employees in certain circumstances. So this is a duty which might arise where a disabled employee is placed at a substantial disadvantage by either a provision criteria or practice, a physical feature of the employer's premises, or an employer's failure to provide an auxiliary aid. The employer will not be obliged to make any reasonable adjustments unless they know or ought to reasonably have known that the individual in question is disabled and that they're likely to be placed at a substantial disadvantage because of that disability. So that also includes individuals who are working from home, and you would need to consider adjustments that can be made at home as well as in the workplace. So, for example, think about when you're setting up meetings for people that are hybrid working. A deaf employee might that uses sign language or lip reading is going to require video calling. Some individuals might need auxiliary aids. So Enhance the UK have some really good tips on that. For example, using the example of a deaf employee again, they've suggested you can use subtitles very easily on Zoom calls or Teams calls, which might also be good for employees with distractions around the house as well, so children or pets that are making noise. Other things that might help on video calls are headphones which fit over hearing aids, neck loops that are compatible with hearing aids and implants, larger monitors that people might need, joysticks instead of a mouse, for example. And also things like body language is really important for individuals that might be neurodiverse. So individuals that have things like autism might need to read people's body language to be able to properly communicate with them. So have a look at that and whether you need to have video calls instead of normal calls. Conversely, people with social anxiety disorders, they might struggle with Zoom calls. So in that situation, you might need to consider how you communicate, how you invite them to attend meetings on a hybrid basis. So it's really, a lot of this is about considering not only your individual workplace, but also about considering your individual employees. If you're ever not sure what an individual who falls within the Equality Act needs, then first of all, obviously consult and ask them. And particularly disabled employees, you should look at occupational health reports as well that might be able to tell you exactly what you can do to adapt the workplace, both in terms of the office and at home for those individuals. Great, thank you. And now we're going to go through our top 10 tips for making hybrid working a success. So the first of those is in terms of checking in. So making sure that individuals who are working from home receive the same amount of management time as those who are in the office. Again, that will reduce this proximity bias that we've gone through. So that can be in forms of scheduling regular one-to-ones with individuals. You could do those both formal, so almost a performance checking, making sure that everybody's okay. But you could also schedule things that were slightly more informal. So we've seen a lot of companies do things like coffee drop-in meetings. So the first sort of hour, everyone can log on and do that, or breakfast drop-ins. Some companies will do things like lunch catch-up sessions, trying to bring those kind of water cooler moments into hybrid working.
Thanks, Jessica. And tip 2, we're looking at boundaries and establishing healthy boundaries. So they're going to be key to avoiding work drift and ensuring that you maintain a work-life balance, which is really important for mental health. So thinking about a defined space for working at home, setting the working hours and sticking to those, taking regular breaks. So it is difficult when you're on screen all the day, and if you were in the office you might be walking around and taking coffee breaks, and you need to be ensuring that you're still doing that as you would do. And of course you've got rights, and all employees have rights to rest breaks and meal breaks, and they need to be taking those. If burnout is an issue, or if you're struggling with mental health, isolation or similar, then you need to be able to raise that and speak to managers and saying that the boundaries are being blurred, and trying to get the support that you need to bring a healthy boundary back.
Thank you. And then the next comment is on avoiding that Zoom fatigue. So studies have shown that Zoom calls are a lot more intense than face-to-face meetings. So what we would suggest there is to ensure that you schedule breaks between meetings and enforce strict time limits on them. So instead of having a full day of 1 hour meetings, schedule a number of 50 to 55 minutes to enable people to take that break and get up and stand and work around. Lauren touched on it earlier, but making sure that there's a safe space of work, including a sort of workplace assessment for screens, and making sure that everybody's got all the equipment that they need. Make sure you send an agenda in advance so everybody knows what's going to be discussed, and also considering whether it actually needs to be a Zoom or Teams meeting. Some things can just be discussed in a call or even set out in an email.
Thanks. And tip number 4 is sharing your working pattern. So we are working differently now, we're working different hours at different times of the day, but it's important that you're able to, or that your employees communicate this clearly. So this can be added to shared calendars so that colleagues know when employees are available. This will help also with, as we said, the healthy boundaries. Adding working hours to email signatures, we're seeing an increase in that with clients and other businesses that we work with, and I find it personally really helpful. Adding details to voicemail if you do have that. Another thing that we're seeing an increase of, which is a very practical but helpful thing, is if your working pattern includes hours outside of those typically worked, then including a note to this effect in your email footer as a reminder, with a reminder that a reply from the other person is not expected until the recipient is in their working time. So that's really helpful. And they're just practical steps about ensuring that your working pattern is communicated with colleagues and other counterparts.
Thank you. One thing that we've seen companies do is adopt what we call a remote first approach. So what the idea of that is that basically you set up your workplace assuming that absolutely everybody is working remotely, even if you have a situation where some people will be coming into the office and things like that. So that would be optimizing the workplace for the remote working. So you may have to create documents, you may have to review your policies, but basically creating these workflows that allow everyone to work wherever they want to. Again, that's going to be really good for reducing this proximity bias. Nobody in theory should be benefiting more than anybody else because you're all working in exactly the same way regardless of where you're sat. It's really good for record keeping in certain industries, so where you've got to keep a record of what decisions you're making, why you're making them, client information and things like that. It's all generally better be kept in one place. If you did have any potential claims against you in this tribunal, the employment tribunal will want to see records as well. So why you made certain decisions, and again, if you're having HR meetings or management meetings as to why you've made them, if you do it remote, you've got those records there, easy to access.
Thanks. And tip number 6 is looking at results-based accountability. So moving from measuring the inputs, hours worked or time visible in the office, we should be forgetting about that now and moving to outputs, tangible impacts on business performance, increased sales, successes, client satisfaction, depending on what you're doing, output focused. This will require a rethink of performance management processes, of course, and a new way of thinking for many managers and businesses. It will be hard, but it's very important to put the time into that, because that is the way to monitor individuals now in this hybrid workplace where we're all working in different ways. your review processes therefore need to be updated, procedures and policies, and this should really be done for annual reviews and any formal processes. So you should look to what you have in writing already as a starting point and seeing what needs to be changed, as well as the mentality side of it, which is output focused.
Thank you. And then the next point is on team building. So one of the potential downsides that we've seen in terms of hybrid working is this sort of lack of cohesion, lack of feeling part of a team, because people can become fairly isolated if they're working from home, particularly if they're doing that on a full-time basis. So ensure that any team building or whole company events that you're running are inclusive. So make sure you invite everyone, regardless of who's actually coming in day to day. Consider how any potential team building can be set up. So consider things like seminars. They could be held on a hybrid basis. You could have people that are coming along and actually sitting there and attending, but also have a function for them for people to attend remotely. If you are running something like that where it's a hybrid sort of seminar, make sure that everyone can contribute equally. Everyone can put their view across. If people want to be able to ask questions, then they should be able to do that both remotely and in person. As we say, just ensure that everybody gets an invite, and consider perhaps how you're going to be able to facilitate everybody being able to attend. If you're doing something like your Christmas meal, consider locations, consider providing provisions for people, travel allowances and things like that might encourage people or assist people that would otherwise struggle to get there.
Tip number 8 is technology and support. So obviously correct technology is going to be key. Employees need to feel confident with the technology they have in place, and they need to have support if things go wrong and they're not there in the office, let's say, to turn around and ask a colleague or a person for help and support. So there needs to be open chains, there needs to be clear lines of communication. We should also be thinking about additional equipment, not just technology, but chairs, monitors and the other things, not only to help people, individuals with disabilities like Jessica talked on, but just generally to help people work from home successfully. We'd suggest a really good tip is just developing Q&A sheets for IT issues, setting up common queries for remote work, having IT contacts, but also just having general contacts and lines of communication when someone is not in the office and needs to raise a concern or has an issue that they need to discuss. They need to be heard, and they need to have someone who is there and available to help them, in the same way that most businesses had open door policies, for instance, in the office. That should be operating in the same way, despite you not being in the same physical room.
Thank you, Lauren. And then we would suggest that obviously you have a policy, and Lauren's gone through how we would suggest you develop that, but also that you train people. So provide training not just to the employees on how it's going to work, but to managers as well. Train them to have on how to handle emotional and difficult conversations related to hybrid working, alongside things that may crop up, such as grievances. Disciplinary issues might be handled remotely as well. There's no reason why they can't be, but it's certainly going to be important to have policies that deal with these things and to ensure that everybody knows how they work. We suggest that you communicate the benefit of hybrid working to everybody. Not everyone's going to be immediately on board with it, but make sure you share the message that that's the decision that the company's made and what the benefits are to individuals and to the company. ACAS have some really good policies and some drafts on hybrid working and what to consider, and we'd also suggest including part of your equal opportunities policy that anyone that does work, a statement that anyone who does work from home won't be treated less favourably and will receive equal access to training and promotions as those who are in the workplace full time.
Thanks, Jessica. And the final tip, tip 10, prioritising mental health. Business does better with healthy and productive employees. Contact between hybrid working workers and colleagues is likely to be less frequent, as we've said, and that makes supervision of work practically more challenging, particularly in relation to your new starters and new joiners. It can make it harder for managers and colleagues to recognise when someone is struggling. So those working at home, we've used this word, isolation, and they might lack the support networks that would otherwise have been available in the workplace. This could lead to performance going down, and then this in turn impacts business. So employers therefore need to be aware of these issues. Appropriate supervision needs to be put in place, and if it isn't, we need to be raising this and saying that there's a missing element. Stress levels should be monitored, and trying to integrate home workers as much as possible, as Jessica said. It does require more proactive steps. It does take more time, and investment is going to be needed. Thinking about a wellbeing programme, a loneliness champion is something we've been seeing, someone who's trained on loneliness and wellbeing, promoting professional and personal networks at work, where you have chats, where you engage, where you have presentations, and making loneliness or isolation part of your manager's responsibilities, so the duty on them to spot it or to help it, as well as training all those who have sort of any form of management on handling emotional and difficult conversations. On office days, make the most of them. So, where people are in, is it a team day? What can we do to get interaction? The commute time that you're otherwise saving, being at home, use that now for wellbeing activities, and employers could be suggesting that. A really good thing to do is conduct staff surveys. They're easy to do now. There's lots of tools online to send them out for free, and invite and address concerns. And that way, employers can show they're doing taking all reasonable steps, and employees are able to put forward their concerns. And finally, managers need to be leading from the top and making their own mental health priority too, so that you can be able to raise your concerns. So there are top tips, and a few final points just before our Q&A section is that that's based on the information and law available as today. If you've got questions or specific needs, you should always check the latest advice and take up-to-date professional advice, lawyers, employment lawyers, tax advisors. We do have a number of questions now, which we will, we hopefully have 10 minutes or so to look over. So we will now take any more questions. Please let us know, and we'll start to deal with what we've got.
Yeah. So we've had a question in on how might I deal with a manager that stopped engaging with me and is declining requests for face-to-face meetings. So you have a right as an employee to raise a grievance, to deal with anything that you might have in terms of an issue within a company. So in that situation, I think if you try to informally deal with it and trying to sort of bring yourself to the forefront of that manager's attention, then I would certainly look to raise a grievance either to HR if you have a HR team, or to sort of senior team. Your company should have a grievance policy that tells you how you can raise that grievance. If not, then if you go onto the ACAS website, then there's a policy there which will set out how you can deal with that. There's also what we call the ACAS code, and that is basically non-statutory guidance that sets out how grievances should be handled by every single employer. If your employer doesn't handle grievance in line with that, then there's potential compensation that can be awarded, or it can affect potential compensation if you ended up in a situation where you were in a tribunal. So employers should absolutely be taking note of that. ACAS do have a helpline as well. They're really useful, that you can call up and ask them if there's any sort of specific questions that you might have on your sort of rights and things like that.
Yeah, and thanks, Jessica. We've had a question that someone's been doing hybrid working for a year and their contract hasn't been changed. So does custom and practice not take over? Well, it does. So, implied terms in a contract absolutely would show that, well, I've been doing this for this amount of time. So if you now try to take that away from me, I think that's a breach of my trust and confidence, and I could challenge that. So that's right. However, technically, the employer should have issued an update to the contract because of Section 4. It needs to be in 1 month of the change. And obviously, having it in the contract is much more certain for everybody than not, because if it's not, you do have a custom and practice argument, but it's just that, it's an argument. So it's open to the employer to also say, well, look, your contract hasn't actually changed. That'll be difficult for the employer where they've permitted it, but ultimately the idea is it should just be updated, and we can do it at any time via a side letter. It's very easy, it just needs to be done in a month, and everyone's got clarity on exactly what their rights are.
Yeah, absolutely, and there is a potential risk of tribunals if you end up with a claim against you for something else. There's a potential piggyback claim if you haven't kept up with your obligations under Section 1 and Section 4 of the Employment Rights Act. So you can be awarded, an employee could be awarded between 2 to 4 weeks pay as an additional for failure to comply with that. So it's not a huge amount, but it's certainly something that you should be able to rectify pretty easily. And then we've had a question, so if an employee is currently working between a Reading office and a home office, would it be reasonable for the employer to change this to London and home? How far would the change have to be deemed unreasonable? It's really going to depend on the specifics of what your contract says, so what your mobility clause says, and also what the job that somebody is doing. If you can justify it for your work and for your business needs, then it's not a huge distance. What a tribunal will really be looking at is how you've handled that process. So have you informed them of this likely change? Have you consulted with the employees on that change, given them the opportunity to kind of engage on why this is happening, why you need it, give them the opportunity to sort of make representations, and then, you know, if this is imposing that change on them, you really need to think about what might happen if they do say no, and they go down the route of saying that, well, that's a breach of contract. But I think in terms of reasonableness, it's not just reasonable in terms of scope, it's more how you handle it. So it's really important to have a think about those processes. Don't just impose a change, make sure you have these discussions beforehand.
Yeah, we've had 2 questions on sort of mileage claims and, you know, how expenses and things work. I mean, there's 2 sides to that. So there's one side is the tax and HMRC, which we're employment lawyers, not tax advisors, so we can't quite go into that. But the other side of it is, what does the expenses policy say? And this is so important as to why thought needs to actually be given to it. Consultation needs to happen. And things need to be discussed and put in place with agreement, really, because not everyone has an automatic right to expenses for travel from home to the office, and really it's important to set out what is covered and what isn't. So you look at your current contract and look at how it's been amended, and, you know, what has changed in terms of the practicalities, and then what really needs to be happening is agreement between both sides on what is covered and what isn't going forward, because, as I said, there's no automatic right that you should get it, but if you've been paid it for a long period of time and you're now things have changed, you need to think about if there's been a loss or anything that's gone wrong there.
Yeah, absolutely. And even if I mean, the HMRC guidance, as I understand it, is currently sort of says that hybrid working is a choice. So they're not too keen on allowing you to claim mileage between a home office and a workplace if you're choosing to do that. But that doesn't mean to say that you couldn't reimburse any potential downfall that an employee has if you were going to introduce that, as Lauren says, put it in a policy. There's nothing to stop you from sort of offering that.
Mm-hmm. There's been a question that there's 100% remote working. The employers decided this, and is there any sort of research on sort of the damage to your trust, communications, and isolations? Well, I think, I mean, specific research we can't go into, but broadly, yes, there's a lot of commentary on mental health and well-being. So while some people are enjoying working from home, there's a mental health element to being isolated, and this is why it's so important now that this is considered, because not only is health important for your day-to-day work, but you could end up with long-term depression or another illness which could end up being a disability, and the employer is at risk of some sort of discrimination treatment. And also, if you are feeling isolated and pushed out, and this ultimately leads to some sort of performance management or something against you've probably got rights that, you know, there has been a breach of trust and confidence, and you're out of sight and out of mind. So it's certainly something that there is. It's a big important topic at the minute, and employers, ACAS guidance does have advice on dealing with this as well. Mental health in the workplace, stress, and we do need to think about the isolation of people not in the workplace.
Absolutely. And on that sort of mental well-being, somebody's asked if they've resigned from a new job due to mental illness and were subsequently overpaid by a couple of £100s and were being chased to repay it by a collections agency. I mean, it really does depend on what your contract says in terms of repayment and things like that. So it depends again as whether the being chased to repay it is in any way connected to the potential disability, and whether there's a kind of harassment angle on that. But yeah, it would really depend on the specifics of your contract. So in that situation, I'd absolutely suggest that you speak to somebody and take specific advice on it, and perhaps ACAS would be able to give you an answer on that. Somebody's made an observation around the free meals that John Lewis are offering to staff while they're working. Have you seen this, Lauren? Where to help with the cost of living crisis, they've said that they're going to provide free meals to anybody that's working in a workplace. Now, the question on that covers tax, which, as we say, we can't really go into. It's not really our realm, but it's certainly quite an interesting point, I think, in terms of things that companies are offering. And as I understand, you can provide free or subsidised meals, providing they're in a sort of workplace and that's up to a reasonable level. I suppose in the same way that you provide tea and coffee facilities or snacks or something to somebody, it's going to be different if you're taking everyone out to a slap-up restaurant. That might be more of a benefit in kind situation. But I don't, in terms of that, I wonder if, Lauren, you have any thoughts on whether that's likely to lead to any issues between providing something for somebody who's working in an office versus providing it to somebody who's working from home? What do you think? Do you think we need to do it for both?
Yeah, I think that needs to be a consideration as well, to make sure that, you know, so things like gym membership, say, if you've got a gym in the office and you're not coming into the office, that's a benefit you may lose from being at home. So employers should be giving thought to, is that still available and accessible? And is it, if the employee is saying, well, it's difficult because I'm not traveling in for various reasons, do we have an alternative? Should we be allowing covering gym membership near the home address? Or is it still available, and is that enough? And again, it's more about consultation. There's no black and white answer to a lot of these things at the minute, and I don't think there ever will be, so long as employer has dealt with it reasonably, listened to concerns, consulted, and tried to come with the most reasonable outcome that can be justified. This is, you know, this is our decision, and everyone is treated sort of in the same way and fairly with it.
Yeah, absolutely. No, it's definitely something for everybody to consider, isn't it? I think, unfortunately, that's all we've got time for today. Our email address is on there, or if you do want to connect with us on LinkedIn or anything, we're always happy to speak about various things. But I'll pass back now. Thank you.
Thank you very much.
Hi everybody, just to say thanks so much to Lauren and Jessica for the most informative presentation. I hope you all found it really useful. You'll receive an email later today, which will include a link to the recording of today's session, a link to the presentation slides, and a feedback link. If you could complete the feedback, we would be very grateful. And thank you so much for joining us today, and we hope to see you at another webinar soon. Take care and enjoy the rest of your day. Thank you. Bye-bye.
Bye.